Hello, my name is Tyler Joseph and I'm an attorney here at Mindell Law. I focus my practice primarily on auto negligence, premise liability, products liability, and civil rights claims. In this video today, I want to give you a general overview of how we investigate and pursue claims and what you can expect as a client from your case. Whenever I'm first contacted by a prospective client, I take the time to get every piece of information that I can. The facts concerning the incident and the injury sustained are the two most valuable pieces of the puzzle that I will need to determine whether or not there is a viable claim. If there's something there, I will proceed with getting the necessary background and treatment information required to open a file. It is important to know that Mindell Law works strictly on a contingency fee basis. This means that there is no financial risk to the client. Unlike other types of lawyers, you do not pay a fee upfront or at any time during the process. As a firm, we only get paid if we win. Our fee is 33% of the recovery, and this is the standard percentage in the state of Michigan. If, for whatever reason, there is no recovery, the client does not owe the firm anything. After opening a file, I may contact witnesses to get their statements, or I may visit the scene of the incident to obtain photographs or measurements. Once I have obtained this preliminary information that I need, I will then send notice to the at-fault party or parties informing them that the client is now represented by Mindell Law. This notice will also demand that a claim be opened with their insurance company. In a perfect world, this notice is sent directly to the insurance carrier and a claim is opened within 14 days. Unfortunately, this does not always happen. Sometimes I need to get the at-fault party on the phone and explain to them the situation. Other times I will draft a complaint, send it to the at-fault party, and threaten them with a lawsuit. On average, it takes anywhere from 2 to 6 weeks for a claim to be opened and an adjuster appointed to the claim. Once an adjuster is appointed to the claim, the insurance company will begin their investigation. This may involve taking a statement from the client and collecting medical records. If I allow a statement, I am always with the client to ensure the adjuster doesn't harass my client or ask any inappropriate questions. Once all the preliminary information is on the table, I will wait until my client has either finished his or her treatment related to the incident or until the treatment has sufficiently stabilized. Depending on the injury sustained, this can take some time. It is important to wait because once a settlement is made, the client cannot come back for more money in the future. For example, if a client sustains a serious back injury in an automobile accident, they decide to settle while they are still pursuing conservative treatment, they will be barred from seeking more compensation should they need surgery in the future. In Michigan, the statute of limitations for filing a personal injury case is 3 years. Unless this date is fast approaching, I always urge my clients to be patient with their treatment before issuing a demand. Once we have a clear vision of the client's treatment going forward, I will advise the client on the demand amount. Once it comes time to issue a demand to the insurance carrier, I will prepare what is known as a demand package. The package will include the facts of the incident, our theory of liability, and a calculation of damages. This will begin the negotiation process. This can involve multiple emails and phone calls with the adjuster discussing issues of liability and the extent of damages. Ultimately, the negotiation process will slow and the adjuster will issue a final offer for settlement. At this point, I must advise my client as to whether or not to accept the offer. If the client accepts, the case settles. The client is issued a check and the file is closed. If the client declines the offer, the only option moving forward is to file a lawsuit. Whether or not a lawsuit is worth the time and energy in light of the settlement offer is complicated. I advise my clients on a case-by-case basis, and no two cases are the same. I have to take into account multiple variables when advising my clients as to the risks and rewards of litigation. If a lawsuit is filed, it typically takes 1 to 2 months of formalities before the defendant appoints counsel and the discovery phase of litigation begins. The discovery phase involves the exchange of information and the taking of testimony. Medical records, incident reports, photographs, and other documents related to the claim are exchanged by the parties. The parties will answer written questions known as interrogatories. The parties will also sit for deposition. Depositions allow attorneys to take the verbal testimony of parties regarding the claims and defenses in the case. The discovery phase can take anywhere from 4 to 8 months to complete. More complex cases may require more time. Once discovery is completed, the parties then attend what is known as case evaluation. In a nutshell, this process requires that the attorneys go before a panel of other attorneys who will award a dollar value as to the appropriate settlement value of the case. The parties will then have the opportunity to either accept or reject this number. If both parties accept, the case settles for that amount. If either one or both of the parties reject the number, certain financial penalties may apply should the case go to verdict. Between the time of case evaluation and trial, the judge will attempt to settle the case him or herself. The parties will be required to attend settlement conferences in court. The judge may also send the parties to a facilitator or mediator who will act as an intermediary in an attempt to settle the case. If there is still no resolution, the next step in the litigation process will be trial. Typically, trial is the end of the road for any case, but there can be appeals. On appeal, a verdict can either be affirmed or reversed, but that is a topic for another video altogether. Overall, the entirety of the process can take anywhere from a few months to a few years. It all depends on the intricacies of each individual case and the client's willingness to settle. Some clients become frustrated with the amount of time it takes to reach a reasonable settlement, but I always assure them that everything is moving forward as fast as possible. Mindell Law doesn't get paid until the client gets paid, and because of that, there is no incentive to let a file sit. Thank you for taking the time to listen to this video, and please don't hesitate to give Mindell Law a call if you are ever in need of a personal injury lawyer.